as we had promised earlier, we have to discuss matters constitution, where we've come from, what we have, and the way forward. And in studio today, as we promised, we're going to have this discussion. So here we're joined by top constitutional lawyer Karanja Kabage. Thank you very much, sir, for making time to join us this morning to answer most of the pressing questions about Katiba.
Thank you. It's a pleasure.
Indeed. Good morning. And we will hopefully be going to Mombasa as well to speak to Kamotho waiganjo, who is the commissioner with the Commission of the Implementation of the Constitution, in a short while. But an important conversation to have. Kenya is at 50. We've seen that report by Innocent Mbaya. It's taking us through the journey. But talk us through what even got us to get into the quest of another constitution, the Constitution of 2010. What began that process?
Well, I think Kenya has come a long way. First of all, as you have seen from the history, in 1963, when we got our independence, we had a constitution that was really a creature of a colonial system. There was very little input, as a matter of fact, by the Kenyan nationalists, even though they went to Lancaster and they had the constitution. Now, when the constitution came, it had certain structures. It provided for a position of the prime minister. We had regional government. We moved on from there. Then we created a very powerful presidency. And we moved on and created a one-party system. And generally, the country did not have confidence in the constitution because the implementation of it was such that it was seen to be very oppressive. And also unaccountable. The executive of the republic could do anything they wished. The parliament was really spineless. The judiciary had been merely made to be a rubber stamp by the executive. So really there was a breakdown of the public confidence in that institution. Then there came the clamor for having a new constitutional dispensation. And in 1995, I remember December 31st, the former president made an announcement that he's going to have a team of experts to review the constitution of the Republic of Kenya. Unfortunately, it did not happen. Now, between 1996 January all the way to 2007, there was a lot of demand by the public for a new constitutional dispensation. And then in 1997, we had the Guy Commission that was intended to come up with a new constitution. They conducted a countrywide tour to get the views of the popularly known Wanjiku. They came back. When they came back, the Constitutional Review Commission, they went to the Bomas, and they had a draft constitution that time. And it was subject to debate by the Constitutional Assembly that had been set up. When it was discussed, we had a first draft from Bomas. And then finally, I think on the 15th of March, 2003, there came out the so-called final draft of the Bomas draft. Then the political class started debating it. They went to Naivasha, had a discussion over there.
Just to jump in, it's clearly been a long journey.
A very long journey.
But one would imagine, as you'd said, Kenyans did not like the initial constitution that we had, and so this journey began to find a new constitution. Why is it that there was such a long period of time before 2010 happened and the constitution was promulgated, in your opinion?
I think, you see, power is very sweet. And particularly those who are donated with the mandate and the responsibility to hold that power, they can exercise it capriciously. They can exercise it for the benefit of the country. They can exercise it to enrich themselves. I think in our own country, it happened that the Constitution then was used to enrich the political class,
right,
and created a serious oppression in the country. I'll give you an example. When it came to a question of alienation of the public land, the president, through the commissioner of land, then he could do anything that he wanted. And that caused us very serious problem.
Right.
And that's why in 2003, when the new government came to power, they constituted what was called the Dongo Commission, which went around and it produced 2 volumes. And those 2 volumes, Annex 1 and Annex 2, has a catalogue of the blunder and misuse and abuse of presidential power to allocate public land to whoever they wished.
Yeah.
And that problem is with us. And that's why with the new constitutional dispensation, there is a creation of what is called the National Land Commission,
Right.
where the executive branch of government, meaning the president, for example, has no powers to dish and allocate land as he wished, because the history that we have come from was so serious. So that's one very, very good example. And as you know, the main thrusts why we fought for independence,
Right.
was the issue of land which had been alienated by the colonial government. And that was a very serious problem.
But what were the points of departure when you're talking about those that were proponents, when you're talking about the proposed referendum 2005? What were the points of departure between the two camps?
Well, the issue was the question of to what extent was devolution going to go? What was going to be the role of the prime minister? Because we had created a position of a prime minister under the Bomas draft bill.
Yeah.
And what was going to be the powers? And what about the president? For example, it was providing that the president be elected by the people, but he didn't have the powers, the executive powers were going to be donated to the prime minister.
Okay.
So there was a major departure
All right.
between the proponents for and against the new constitution.
Okay.
So then, of course, the rest is history until we went to 2009 and we started the journey towards the new constitutional dispensation, which was passed on 4th of August and then on 27th of August 2010.
It was promulgated.
We had the constitution promulgated.
Yeah.
Yes.
All right. Looking at the document as is, what the drafters that put together the document, what were the aspirations? What was captured in there for the people of Kenya? Because it was a big moment, as the former president said in his speech on that day. It was the biggest moment in Kenya's history.
Yes.
You agree with that kind of significance that was given to that?
I totally agree with that sentiment. You see, the constitutional framework that we created, and I think this is important for people to understand, it tried to create power centers that are devolved. For example, we have the 3 arms of government.
Right.
You've got the executive branch of government, headed by the president. You have got the parliament, headed by 2 speakers, the Speaker of the National Assembly and the Speaker of the Senate.
Yeah.
And then you have got the judiciary that is headed by the Chief Justice. Now, these 3 bodies today, as provided for in the Constitution, they are fairly independent. There's no question about that. But then the crucial thing is when we created the devolved government. And in the devolved government, we came up with 47 counties.
Yes.
Now, those counties, as a structure, people need to understand is the following. We have the governor and his deputy, who is popularly elected by the people. And then we have got an MCAs, members of the county assembly, again elected by people. Now, the governor at the county level is the chief executive officer of the county. And he has his cabinet, what is called the county executive committee, maximum 10. Not all counties have got 10 because it depends on the population. And then you have got the county assembly. The county assembly is the law-making body. It does not make bylaws. It's a law-making body.
Right.
And it's supposed to be having powers of making laws. It oversights on the budget. It must pass the budget of the county. It must be able to ensure that anything that goes on as far as the executive branch of the government, of the county government, it has oversight responsibility.
Right.
So it's really a parliament that makes laws that have a force of law, both constitutional and legal.
All right.
Yes.
We want to just remind our viewers as you watch this conversation, you can be part of it. If you have a question or a comment, a contribution you'd like to make this morning, our numbers will be on your screen. You can call in and definitely engage with us this morning. But let's get to now, since the Constitution was promulgated, some keep saying new Constitution. I don't think it's no longer new.
It's the Constitution.
It's been here for a while now. But quite a number of challenges have come with it, or we've been able to witness quite a number of things said, including amending of it already. That conversation has been had. But let's begin with the wage bill. Some have now argued that with the creation and the devolution and the creation of all these offices, it's become quite expensive. That perhaps it's something some would say they did not see, were not aware that with coming in of this supreme law, that also paying for it and paying for what it created would quite the tall order.
Well, I think Kenyans must appreciate one thing, that democracy is very expensive to begin with. But how we manage our democracy is an issue. Now, what kind of men and women did the Kenyans elect to parliament and the county assemblies? Now, first of all, I think people should appreciate that this constitution, it's unique.
Right.
Unique to Kenya, and I think in the world, this is not a constitution you'll find very anywhere else. One, we have elected leaders who include the members of the county assembly, the members of the National Assembly, the women representative, the senators, the governors, and the president and his deputy.
And you also have the nominated members of which of those groups,
Yes.
some of those groups you've mentioned.
Yes, and we have, for example, if you go to the county assembly, the constitution is very clear. It provides that we needed to have at least 1/3 of gender content of every county assembly. But if it did not have, it provided 4 nominations. So we have a big number of people that have been nominated to be members of the county assemblies.
To meet the threshold.
To meet the threshold. And the intention or the mischief that was supposed to be addressed by that nomination is that when laws are being made, there has to be sensitivity that is brought to bear. What is the expression of those laws? I think for a very long time, we must admit that our parliament, or even the former councils, the most elected people were men. Women rightfully felt that they were being marginalized because they didn't have a role to play as far as input into the legislation of the laws is concerned.
Hence the affirmative action.
Hence the affirmative action.
But back to the wage bill question, because you have so many of these people now.
Yes.
A lot of the money that's collected from the taxpayers is going to pay them.
Yes.
Was that what really Kenyans wanted at the end? Should these conversations we are hearing about perhaps scrapping some of these positions take place, reducing the number of counties? What are your thoughts?
You see, wage bill is just one aspect. But you see, one of the things that we need to address is the whole question of allowances. There's so many allowances that are given and paid to all these elected leaders, besides their salary.
Yeah.
That's a huge area. The other one that is a problem is the efficiency with which we use the tax dollar or the tax money, the tax shilling that we generate in this country. There is a lot of waste. There's no question about that.
Right.
And if we are honest with ourselves, we must say maybe the role of the Salary and Remuneration Commission is probably not being executed as it's supposed to be. Of course, there was a lot of push and pull when the members of parliament, members of the National Assembly, let me put it that way.
Yes.
They said they rejected the salaries that had been recommended or proposed. And in fact, what a lot of people don't realize, the members of parliament did not have an option. But somehow it appeared as if there was a concession. And they managed to get their end of bargain, which to me was very sad. I thought that the Salaries and Remuneration Commission, which is a constitutional commission,
right,
under Chapter 15, they should have stuck their gun and let the matter be escalated all the way to the Supreme Court to make a determination. But as of now, the members of parliament, in my opinion, they're earning salary that is not constitutional. So
for you, reducing the numbers, scrapping some of these nominated positions, as we've had some calls for, is out of the question, is not a necessity?
You see, okay, first of all, I think we see a constitution is not cast in stone.
Right.
Yes, we promulgated a constitution, but one thing that we have to realize, it is work in progress.
Yeah.
Now, when it begins to work, then we need to ask ourselves, is it working according to our aspirations and expectations? Certainly, there may be need to make a surgical review of the constitution, but it's too soon. My view is that let us give it the next 4 years,
all right,
up to maybe 2017, and we begin talking about the new dispensation, because you need to audit. Right now, what we're having are expressions of it is too high, it's too expensive. It's true. The wage bill of the country is substantially very, very high. But it is not necessarily a wage bill based on elected leaders, because that's just part of it. We need to look at what happened, for example, and this is something that people are not addressing.
Right.
When 2007 election took place, and we had a crisis, we created a coalition government. Now that coalition government, it had about 43 ministries. Now, it's not just cabinet ministers. There was a huge bureaucracy that was created.
All right.
Now, when the new election took place in 2013, now, yes, the president collapsed the ministries, but what one may need us to ask is, what about the bureaucracy that was created? Did we shed off the bureaucracy?
Yeah.
We probably never did shed off the bureaucracy.
You still have so many people working under that one person.
So we need to audit
that. Okay.
You know, that aspect.
All right.
Yes.
We want to bring in Kamotho Waiganjo, who's a commissioner with the Commission of the Implementation of the Constitution. He's joining us live from Kwale. That is where the Devolution Conference is taking place. He's going to be part of that team. It's good to see you, sir. Good morning.
Morning, Sophia. How are you?
I'm great. Perhaps I'll begin on a scale of 1 to 10. You are part of the commission charged with the implementation of this very important document and the supreme law. How do you think Kenya is faring so far, 4 years into the constitution, as far as implementation is concerned?
Sophia, I think in different areas we have we have had different successes. I would say in terms of the laws that are necessary to ensure proper implementation of the Constitution, we're probably doing a good 7 out of 10. I think on the institutions that again were necessary to ensure the implementation of the new constitution, again, we're doing maybe a 6. If you look at the legislature, the county assemblies, the county governments, we're doing well. In terms of managing the bureaucracy, I think we're doing a poor 4. I think we have too much duplication in terms of previously existing offices that have still not been transitioned out. We still haven't gotten the quality of people at the county government, at the bureaucracy level, who can deliver on the services that those counties are required. So I think there we're doing badly. On the delivery of services, I would say we're probably doing maybe 4 or 5. I think Kenyans haven't felt the impact of devolution as they would have wanted to. And there are many reasons for that. And it's not to blame the county government. It's to actually say that's our reality. So in different ways, we've accomplished different things. In terms of the public participation in governance, Sophia, we're doing very well. If you think about it, in the last 50 years, the nature of conversations on policy, on law, on governance that have happened in 50 years is almost equivalent to the amount that we have had in the last 1 year. Okay. For the first time in our history, we are asking questions about budgeting, about accountability, to a level we haven't had before. So we've had different successes. We've had significant challenges in some other areas.
All right, you talk about public participation on an increase there, but also we've had many argue that the majority of the Kenyans don't seem to have an understanding of the constitutions. Many have not even read the document. So how is that pairing?
That, by the way, is a reality. The truth of the matter is that because the process leading up to the referendum was a very politically heated process, not many people actually interacted with the Constitution intensely. Right. So a lot of people are having to learn its content now by seeing the institutions working and wondering, what is this? We're used to a particular way of doing things. So yes, there is a challenge at that level, but don't underestimate Kenyans. If you look at the discussions that have happened, particularly on the question of planning, and even in terms of accountability, and the fact that in almost every place in this country now, every county headquarters you go, where either people felt that the taxation levels were too high, or the utilization of budget by the county governments were unfair. You've even had in some places demonstrations for the first time in about 50 years. So yes, people may not understand all the intricate details of the Constitution, but I think they're starting to realize that we have a new governance structure, that this governor is our government, that this money is our money. So that is what is happening. And one hopes, of course, that will be informed by more and more education. But the fact that Kenyans are starting to hold government accountable at the grassroots is one of the more important aspects of our reform process.
All right, stand by. We'll continue to talk to you as we go along with this interview. Let's bring you in again, Kabage. And in as far as what he's just talked about, Kenyans and their involvement and their understanding, do you agree that yes, whilst many may not have read the document, when they see some things are not working out, they will speak out against them?
I think we must acknowledge one thing, that the democratic space has been expanded to the extent that Kenyans are, even without reading the Constitution, they believe somehow that there is a document allowing them to demand and to participate. Now, my view is that for example, at the county level, I'm convinced there is a big problem. Mm-hmm. And the problem is we have very many laws that govern the county, what you call the devolved system. Let me give you examples. We have, for example, what we call Urban Areas and Cities Act. We have what we call Transition to County Government Act, to Devolved Government Act. Mm-hmm. We have what we call County Government Act. We have what we call Intergovernmental Relations Act. We have what we call Integrated Financial Management Act. We have a Revenue Act. We have even things like Public Procurement and Disposal Act. Mm-hmm. We have even things like, for example, understanding the Commission for Revenue Allocation. Okay. We have even things like understanding Salaries and Remuneration Commission. We even have to understand the role of the Auditor General. We have to understand the role of Controller of Budget. Okay. Now, all those things, besides the Constitution, the government at the county level needs to understand. For example, if we take about the County Government Act, which is today what we call chapter 265 of the laws of Kenya. There is a very express provision allowing for public participation. That's what my good friend Kamotho was referring to, that the governors have not involved the public. For example, if you are saying that you want to finance a certain activity, you don't just pass a bill or a law or finance to charge taxes. The public ought to be involved.
Of that.
The law, that chapter, that County Government Act provides for participation of the public. They are supposed to be informed that we want to increase taxes, and the reason why we want to increase taxes is because of ABCD. Now, they are not doing that.
Okay.
And that's why you're finding protest. But I'll also give you another example. In all the county assemblies, there is what is called County Assembly Service Board. The County Assembly Service Board is composed of the speaker, the leader of the majority, the leader of the minority, and one more person who is supposed to represent the public. Unfortunately, if I can give you an example of Nairobi, they are operating a county service board without the inclusion of a person appointed from the public.
Okay.
And they are now spending money,
right,
very serious money, without adhering to Section 12 of the County Government Act that provides that you must establish a county service board.
Right.
What does that mean? It means they are actually abusing their position. And very soon somebody will go to court and they'll have a very serious problem. That's one simple example.
One simple example.
Yes.
Let's now talk about some of the sticky issues we've seen play out in the news. I'll bring in Waiganjo at this particular point again. On the question, for example, of supremacy wars, Waiganjo, we've seen pitting the Parliament, National Assembly and Senate. Is it that the Constitution is not clear on who does what, on whose roles, their mandate and all, or what is going on as far as that is concerned, in your opinion?
I think, Sophie, it's a combination of issues. The reality is that there is only so far the Constitution can go in terms of defining roles with specificity. It's almost impossible to ensure that there are no jurisdictional interferences between institutions. But there are certain things that the Constitution assumes. One is that if you look at the way we have structured our constitutional framework, is that even though we have independent organs, there's a spirit of consultation and comparison that is required. So the Constitution actually presupposes that where there are going to be differences in terms of views between institutions, that there's a process by which those differences can be resolved. So that's number one. Number two, the Constitution assumes that the caliber of leadership in those critical institutions, whether we are talking about the judiciary with the office of the Chief Justice, or the legislature with the office of the speakers, or the executive in the office of the president and his deputy, the assumption is that the men or women that will have elected or appointed to those positions are of the caliber that they would not allow runaway disagreements. Because what you don't want is runaway disagreements. Obviously, there are going to be challenges here and there, but you don't want this conversation playing out as if we have a crisis in government. So sometimes what has not helped is that those informal conversations between those three levels of government have not happened. The final thing to say, Sophia, is that, the Constitution does not concern itself with supremacy and who is more superior. The Constitution allocates responsibilities to different institutions and says you carry out your responsibilities. The people decide who is superior and who is supreme. It is not for us to say X number one is the one who is superior in terms of ranking. The Constitution does not concern itself. In fact, Sophia, at some point when the Constitution was being made, there's a time a clause had been put which had said that the National Assembly is a upper house, and that clause was removed because they said, why should we be concerned with saying which is the upper and which is the lower house? So one hopes that as institutions get into their own traditions and people find a way of working together, a lot of these things will go, and one hopes that these are just the challenges of the first years of marriage, and that as we go ahead, some of the more runaway areas of disagreement are going to be reduced. But having said that, it's inevitable, and we are not the only jurisdiction where institutions always challenge one another. What you don't want is that leads to a crisis or where institutions are not able to carry out their functions.
And another one very quickly, the judiciary is envisioned to be perhaps the one which gives clarity, the way forward when such matters arise. But in the recent past, we've seen it as well embroiled in those supremacy battles, the CJ coming out to clarify that whatever comes out from the courts, no matter what it is, it stands. So then what becomes the recourse for Kenyans when there is no clarity and everybody is fighting the other? It's push and pull.
The reality is that the Constitution is very clear on where the final word is. We are a constitutional democracy. We are guided by the Constitution. The final determinant of what the Constitution says is the judiciary. That is what the Constitution itself says. So at the end of the day, even where the judiciary will be wrong, and that is why in the judiciary you have an appellate process. That is where you move from the High Court to the Court of Appeal to the Supreme Court. The reason is that by the time the decision comes to the Supreme Court, the decision will have been looked at many different levels, and what the Supreme Court will produce is the right decision. But finally, whichever court produces a decision, that decision under the Constitution is final. So that there is no contestation as to who has the final word on what the Constitution says. So I think it's important that we realize that we have come from a very different arena where the word of the executive sometimes was final, the word of the legislature sometimes was final, but the Constitution has said when it comes to matters of what the Constitution means, when it comes to what the rights of different individuals are, when it comes to what the rights and obligations of different institutions are, the judiciary is the final authority on the point, even where the judiciary can be wrong. Of course, that comes with a lot of responsibility on the part of the judiciary to ensure that their decisions are credible, they are legitimate, they are legal. But at the end of the day, the final determination is by the judiciary.
All right. Kabage, weighing on the same, because, when the judiciary then has such a huge task and mandate on them, it is unfortunate when they also seem to be part of the problem.
Well, I think the point that we must acknowledge is that there is no infallibility, even on the part of the judiciary. But, you see, as a country, we must acknowledge one thing. There has to be a point at which disputes must be brought to some closure.
Yes.
And obviously the judiciary has a very onerous responsibility to weigh in their decision. And as Kamotho says, we have no any other way out, because in the absence of having a judiciary that comes up with a decision of saying this is what should be followed, then we are going to create anarchy. Now when you have anarchy in a nation, everybody is a loser. So for bad, for worse, we have to abide by what the Constitution provides for. Now, I would say that the judiciary obviously has to be also sensitive to whatever is being talked about, so that when they make decisions, they are within the law and the Constitution. And I think that is really what should be happening. But I agree with Kamotho 100% that finally the judiciary has to make a determination which way to go in the event of disputes.
Okay.
Yes.
And you did mention for you, in as far as those calls on amending the Constitution is concerned, you think a few years should be given before such a move is taken. Kamotho, I'll come back to you. What are your thoughts? We've heard about some talking about reduction of the number of counties, scrapping of some of these nominated positions. Do you think it is that time the country starts having that conversation on amending the law? The Constitution?
Amended our Constitution. We have hardly started implementing our Constitution. We haven't done most of the things that, especially the things that matter to the common mwananchi. A lot of those things we haven't done. We even haven't seen how institutions work. Of course, we are realizing some challenges. But the question is, at this point, should the conversation be about especially ensuring that we have implemented the remaining parts of the Constitution rather than starting to talk about amendment? And I'll tell you why. We talk about the wage bill, for example. One of the things that is explaining the exploding wage bill is because we continue to retain the old wine in the new wineskins, so that even though we have a new constitution and we have new institutions, we still retain a lot of the old institutions. I'll give you an example. We had about, 200 or so odd parastatals. A lot of those parastatals were carrying out functions which have now been devolved to county governments. There's no reason for some of those parastatals to still be in office, but they continue to exist with their boards, with their secretariats, and their huge outlay of expenditure. If we were to at least remove those, if we were to go to the what was called the former provincial administration and adjust it, not remove it, but adjust it, reform it in the way that the Constitution anticipates, so that you don't have to have duplication of services. Again, we will deal with part of our wage bill issue. If we were to deal with the question of the SRC actually carrying out responsibilities, ensuring that people are not getting illegitimate salaries and allowances, again, we would reduce the wage bill. So what we need to be concentrating on is ensuring that in terms of what the Constitution requires, let us implement those aspects. Of course, this Constitution is not the Bible, it's not the Quran. At some point, we need to sit down and ask, which are the areas which are a challenge? But let us not forget why it is that we instituted some of the provisions. I'll give you the example of the women's seats. It is Kenyans who said they would like all genders to be properly represented in legislative bodies. Now, they could have elected those people. If they had elected women, we would not have nominated. But Kenyans cannot insist on electing men only and then say we don't want to nominate women. It's a choice Kenyans must make by saying that every gender is entitled to sit in the places where decisions are being made. And that is not necessarily just good for women, it is good for the country. So it's to say that as we rush to solutions, let us also understand where we are coming from. We're a country that for many years people felt excluded. You know, for many years people felt excluded. Women felt excluded. So part of the price we must pay in including people is ensuring, one, that people elect. But if they don't elect, that we nominate. So yes, amendments, but let us wait for another 5 years, maybe even another 5 years to really be sure what are the changes we need to make. And when that happens, let it be a national conversation. This Constitution took so many years and so many people to have a conversation about how it is structured. When it comes to amendment, let it not be a decision only of the elite in parliament or the elite in civil society. It has to involve most people, most Kenyans.
All right. Kabage, another sticky issue we've seen is with the lands sector. The NLC chair, the cabinet secretary at loggerheads, you know, tough wars that have played out in public for quite a number of weeks now, and even interfering and affecting service provision. And it's really about each arguing, this is my mandate, this is what I'm supposed to do. What does the law say? How is this playing out, and we're not having a final word anytime soon yet?
Well, I think, as Kamotho says, our challenge right now is making sure that the institutional frameworks are in place and people understand what is their mandate. For example, you know, this country has had very many laws, but now we have reduced them to 3. We have got Land Act, we have got Registration of Titles Act, and we have got National Land Commission. Those are the 3 institutions. Before then, we had so many, you can't even believe. I wish I had time to be able to talk about them. Now, today, the Cabinet Secretary for Lands, Housing and Urban Development, and the chairman of the National Land Commission, I think to me there is what I would call territorial war. Each one of them is trying to assert themselves, but they must realize in that process that the sufferer is the grass, which is the public. And I believe this thing is playing out because there is probably need for clarity of who should do what and who shouldn't do what. And remember, why we fought for independence in this country was because of land. That docket has always been very controversial because it is the docket that allocates, is the docket that registers. Now, that to me, I would say, and we don't have enough time to really go into who should be doing what, who should be doing what. So there is a problem of territoriality. And there is need, therefore, for making sure that the 2 very, very important offices, the Cabinet Secretary and the Chairman of National Land Commission, there will probably be need of some sort of intervention to ensure that, hey, wait a minute, and I understand that the Supreme Court is being called upon to give its opinion. Let us wait for that opinion. Because when it comes out, to clearly lay out what are the mandate of National Land Commission and what is the mandate as envisaged in the Constitution. Yes.
All right, and let's come back to you, Kamotho, because this has played out for a while, and as you're a commission and a body that's charged with helping out to the implementation process, who's wrong? Charity Ngilu, Swazuri, who's not quite telling the truth in as far as what they're supposed to be doing and not doing?
I think every one of them has a little bit of truth and a little bit of, I'm told leaders don't lie, they only tell misleading truths. I think we have some challenges, not so much in terms of understanding mandates, because we've had at least 3 major meetings with the minister and his team and her team and the commission and its team, ourselves as a commission and other government officials. We've had very long meetings, and generally the issue of mandate is agreed. The problem arises as to, now that the mandate is agreed, how is it to be effected? Because the understanding of the mandate has implications. I'll give you an example. It's, for example, agreed in terms of the extension of leases issues, which is a current controversy, that the responsibility of determining the extension and issuing the leases thereafter is a National Land Commission. But the law also requires that before the Land Commission does that, it has to seek the consent of the ministry. Now, the question as to how that process is played out, which requires, like I said in the beginning, consultation and cooperation, is actually the problem. It's actually more administrative than legal. Now, unfortunately, that's why I said that the persons we have placed in these offices are assumed to be of the caliber where they are able to reach agreements that are reasonable and that are rational. We have not seen that in respect of some offices. And I think we need to speak to the leaders who have been given positions, including the Cabinet Secretary and the Commission, that it is more important that they establish working modalities before Kenyans start saying that they're starting to become irrelevant, because Kenyans are struggling every day. So I think it's to say to the two institutions that now that the mandates are generally agreed, in fact, they don't need to be resolved by the Supreme Court, the administrative issues that are required, which require the two offices to work together, how can they be worked out? And that requires leadership. And sometimes these things, Sophia, are actually a failure of leadership, more than issues of conflicts in the law.
All right. As we wind up with you, Kamotho from Diani, we appreciate you making time to be with us this morning. A final question to you. As CIC implementation key, as we're talking about the Constitution, do you feel you've sufficiently helped that process in as far as giving out clarity whenever there are questions being raised, ensuring that there's a clear understanding and the implementation is going on as it should, and in terms of capacity and facilitation to be able to do your mandate? Has that happened? Are you on course?
I think we have done what we could, Sophia. I think let history judge us. I think we should be the wrong people to pat ourselves on the back and say we've done very well. Obviously, we could have done a lot better, but I think we have done the bit, not both at technical level. We've ensured that the laws that needed to be there at least are in place before we are out of office next year. The institutions that needed to be there and that will survive us are there. I think we have tried to engage the public so that the public recognizes that even where they don't understand the Constitution, there's something called a new Constitution which places new demands of government. I think we've done that very deliberately. I think we could have done a lot more in terms of civic education. We could have done a lot more in ensuring public participation in lawmaking and in policy formulation. We could have done a lot more in terms of ensuring there is less disagreement between institutions. But within the limited time that has been, I think we've done a bit. But, the people of Kenya will decide, and we hope that they'll give us a good pass. But either way, I think within the human capacities, I think the Commission has tried. Many challenges remain once we go. We will still need to ensure that the constitutional implementation does not go to the back burner. And the media, the civil society, and public institutions must own that space, even when the Commission leaves office.
All right, Kamotho Waiganjo, thank you very much, Commissioner with the Commission of the Implementation of the Constitution, joining us live from Diani, where that devolution conversation and conference is going on. We thank you for making time for Morning Express. Finally, with you, you've heard what he had to say in as far as their body and this role, because it's a key mandate they have when we're talking constitutional matters. What are your thoughts? Have they done well?
I think it's true. The Constitutional Implementation Commission has exercised its mandate pretty well, we must admit. And I must also say that there was a timeline. If you look at Schedule 5, among the 6 schedules of the Constitution, there are timelines when certain laws should be passed.
Right.
We haven't passed all the laws. And I am looking forward personally to an extension of the term of office of the CIC, because it is provided for in the Constitution.
Right.
Because we need that body, in my opinion, for another 5 years minimum, so that we can be able to smoothen the rough edges as far as implementation of the constitution. And also I must admit that Kenyans must realize one thing. Constitution making is one thing. As the English people say, the proof of the pudding is in the eating. Now we are talking about implementing the constitution.
Right.
We had a wonderful month of having to make the constitution. We even had a wonderful feast during the promulgation of the constitution.
Right.
But now implementing the constitution to the letter, we require much more time, no question about that. We also require men and women of goodwill who have been given responsibilities in the various positions so that they understand that this is a historical mandate to ensure that Kenya is smoothly implementing this constitution. Because you can look at the entire continent of Africa, you can look at the entire globe. There is no any other country that has this kind of constitution. In my opinion, if we are faithful to the aspirations, the aims and dreams that we had of coming up with a new constitutional dispensation, if we can keep it alive, I do believe that it is going to serve us very well.
All right.
But finally, let me put it this way. There is no substitute whatsoever to the players, whoever they are, in understanding what is required by the Constitution and what is required by the various laws that have been made or have been passed in order to implement smoothly the new constitutional dispensation.
Right.
There is absolutely no substitute.
There is no substitute, and we do hope, as you said, the dreams and aspirations of the Kenyan people will indeed come to be a reality. Karanja, Kabage, we appreciate you being with us, an advocate of the High Court. Thank you very much for being part of our Kenya at 50, the Constitution being our focus this morning. And you and Waiganjo of CIC did express that perhaps more time needed before we talk about amending the law.